Get ready, start. This appeal by special leave is directed against the judgment and order dated 28 August 2014 of the High Court of Delhi, allowing the revision petition preferred by the respondent or plaintiff against the order of the trial court, which has dismissed her application in a suit for recovery of possession and damages with respect to a portion of the property being in unauthorized occupation of the appellant or defendant. The plaintiff respondent filed a suit against the defendant or appellant, who is her son, for recovery of possession and damages, alleging that she had purchased the suit property out of her own fund and she is the absolute owner. But part of the property was under the illegal occupation of the appellant defendant, who opposed the suit, contending that the suit property was a Hindu undivided family property having been purchased in the name of the respondent using the funds of his grandfather, father, and himself, and not purchased by the respondent as she was a housewife having no income. Appellant defendant further pleaded that though there was a dispute regarding his ownership and possession, the same was settled between all the family members via compromise deed dated 27 October 1997. The respondent filed an application under Order 7th Rule 6 of the Code of Civil Procedure for passing a decree in her favor on the ground that a suit for partition, which had earlier been filed by the appellant on the same ground, that is, that the suit property was a HUF property, had been dismissed by the District Court by judgment dated 8 September 2003 and affirmed by the High Court by judgment dated 12 September 2011. And the respondent contended that the same amounted to an unequivocal admission by the appellant and that the respondent was entitled to possession. The trial court held that though the judgment dated 8 September 2003 of the District Court and judgment dated 12 September 2011 of the High Court had rejected the plea of the appellant that the suit property was a HUF property, these findings were made in a suit for partition, whereas the present suit was filed for recovery of possession and damages. The trial court further held that for passing a decree order under 7th Rule 6 CPC, the defendant had to make an unequivocal and unqualified admission. The appellant herein has not made such an admission regarding his liability to pay the damages claimed by the respondent. The trial court dismissed the application by judgment dated 7th June 2013. Aggrieved by the judgment of the trial court, the respondent filed a revision petition before the High Court. The High Court, while allowing the appeal and decreeing the suit with cost, held that pleas taken by the appellant defendant regarding the contribution made by his grandfather, father, and himself in the purchase of the suit property had been rejected by the court by judgment dated 12 September 2011, and same will operate as res judicata. The High Court further held that while there was no evidence for holding the suit property to be a Huff property, the title deeds of the suit property and land records stood in favor of the respondent plaintiff.